Good afternoon, everyone, and welcome to our webcast on navigating changes for employers in the nonprofit workplace in light of the COVID-19 crisis. My name is Lori Shapiro, and I'm the employment attorney for Pro Bono Partnership of Atlanta. Thank you very much for being here today. Just a little bit of information about Pro Bono Partnership of Atlanta before we get started. Pro Bono Partnership of Atlanta provides free legal services to nonprofits that serve the poor or disadvantaged in the community. We serve clients who are 501c3 organizations who serve the poor disadvantaged in the greater Atlanta area. And if you'd like to apply to become a client, if you're not already a client of ours, please go to our website and you'll see information there about becoming a client of Pro Bono Partnership of Atlanta. I want to thank each and every one of the nonprofits who are participating in this call for all the wonderful work that you are doing and for continuing to do your work to help the community. It's really a difficult time, I know, for everyone. And today we're going to spend some time discussing the employment issues that are coming to light with regard to this crisis that everyone is experiencing. When I talk to clients lately, they are all expressing concerns about each of the items that I've listed here on this slide. The pandemic is changing the way that business is being conducted. Nonprofits are concerned about being able to carry out their mission in the current climate, and many of our clients are being wonderfully creative in the ways that they're addressing some of these concerns, including seeking changes to restrictions on their funding to help address operations, looking for new sources of emergency funding, providing remote services to clients where that's possible, and changing the ways that their staff is working and their organization is working with volunteers. Changes are happening every day. What I'm going to do on this webcast is do my best to provide you with information that's based on the information that is available to us right now. So please be aware that what we discuss may change if there are legal changes after this webcast is presented. Please also be aware that this webcast is for informational purposes only and should not be considered legal advice. If you have a specific legal question, please contact your Pro Bono Partnership attorney after this call or after this webcast. Please also be aware that I've tried to incorporate answers to some of the questions that we received before the webcast into the presentation. Please feel free to use the chat function to post questions, but be aware that I will try to address as many of your questions as I can at the end of the presentation once I get through the material where I've incorporated some of the answers to the questions you've already raised. So let's dive into some employment issues that you might be thinking about. First of all, let's talk about where you're working. Is your office or facility remaining open, or is it closed? And if it's open, have changes been made to your facility or to the way that you're working in your facility because of, because of the changes that are going on in the world? The first thing I wanted to point out to you is to be aware that the Occupational Safety and Health Administration, or OSHA, imposes a duty on employers, all employers, to maintain a safe work environment. That duty applies even if you're not one of those employers who's subject to the record-keeping requirements that OSHA puts into place. And those record-keeping requirements apply if you have more than 10 employees, and there are a lot of exemptions for specific industries where a lot of nonprofits work. I'm not going to get into all the exemptions to the OSHA record-keeping requirements, but I do want to talk about how you maintain safety in your workplace. So one of the things that you may have already done or may want to do is communicate with employees about the CDC guidelines and any changes to workplace processes that are required by social distancing. So let's talk in a little bit more detail about how to maintain a safe work environment. First, Can we screen employees for illness before allowing them to come into our office or facility? And can we require employees to stay home if they are experiencing symptoms or if they've been exposed to COVID-19? Even if you're covered by the Americans with Disabilities Act, if you have 15 or more employees, or the Federal Rehabilitation Act, which is the law that prohibits disability discrimination by federal contractors, your organization in this crisis is permitted to make medical inquiries. The Equal Employment Opportunity Commission has issued an opinion indicating that COVID-19 is a direct threat to employees in the workplace. And because it's a direct threat to employees in the workplace, you can ask employees about their symptoms and take their temperature before you allow them to come into your workplace. If an employee has symptoms or has been exposed to someone with symptoms, you as an employer can also require that employee to stay home and not come into work. I've been getting a lot of questions from our organizations who have been given information by employees regarding the fact that an employee has tested positive or an employee has symptoms of the disease, or someone else who's been in their workplace or around their employees has such symptoms. And the issue that you need to consider here is that it's a real balancing act that you need to achieve. You need to balance the need to keep medical information private against the need to provide information to employees so that they have sufficient information to understand that there has been a risk. If you're communicating with employees about someone who's been exposed to the disease, you need to indicate that there's been an exposure without identifying the name or specific identity of the employee or individual who's been exposed. So you want to maintain that difficult balance between giving enough information so that employees understand that there was someone in the workplace who has symptoms or has tested positive, but you don't want to identify that particular individual. Let me also speak briefly about potential workers' compensation claims related to employees in your workplace. In Georgia, there is an available compensation claim for occupational disease. So occupational disease can be an event that triggers workers' compensation coverage, but please be aware that a diagnosis with COVID-19 would have to satisfy a number of factors to actually be compensable under workers' compensation law. And those factors include a direct connection to the job and also an illness to which the general public has not been exposed. So it may be unlikely that a successful workers' compensation claim can be filed for COVID-19, but what I would caution you is that if an employee claims that they were exposed to COVID-19 at the workplace, then you should report it to your workers' compensation carrier and allow them to make a determination as to whether that claim will be covered or not. They'll look at the specific facts of the situation in making that determination. So don't assume that there's no workers' compensation coverage. If somebody makes a claim, go ahead and submit it, and then there'll be a determination made as to whether workers' compensation will cover that claim. I want to move on now to talk about the new Families First Coronavirus Response Act that has been enacted. So the Families First Coronavirus Response Act provides new benefits that are in addition to any benefits that you previously provided to your employees. It goes into effect for any leaves that begin on April 1st, 2020, and it ends with regard to leaves on December 31st, 2020. So it's only a temporary measure. It's only in place from now until December 31st. The Department of Labor has indicated that regulations are going to be issued. In fact, they say they're forthcoming to address the potential exemption of organizations with less than 50 employees under the Family First Coronavirus Response Act. Those regulations have not yet been issued, but I did want to share with you that the Department of Labor has put out a question and answer session, or a question and answer sheet, excuse me, that indicates that if you're providing family or sick leave, if providing paid family or sick leave would jeopardize your business, and you're a business with fewer than 50 employees, then the organization should document why. Unfortunately, what the Department of Labor says is that the reason why needs to be tied to specific criteria, but the criteria have not yet been issued by the Department of Labor. So we are keeping an eye on Department of Labor information, and we'll send out information in a legal alert when the regulations are issued that give us more information about the parameters for this potential exemption for employers with 50 or fewer employees. In general, related to the Families First Coronavirus Response Act, you are required to post notices in your workplace if you're required to comply with this law. And the Department of Labor has issued postings related to the law. So if you are working in a facility, if you still have employees in your facility, the notices need to be posted in the facility. You can obtain those notices on the U.S. Department of Labor website. And if your workforce is working from home, you will need to issue those notices to your employees so that they can see them, either on some kind of intranet if you have anything like that, or by email or some other method of communication with your employees. I want to talk in much more detail now about the requirements of the Families First Coronavirus Response Act. So there are really two new leave entitlements that have been created under this act. The first one is the family leave. And family leave, as you can see on this slide, is leave to care for a child of the employee who's under 18 years old if the school or place of care has been closed, or if the child care provider is unavailable due to a public health emergency. So this is really child care leave for any child under the age of 18 who the employee claims needs care. It applies to, as I mentioned earlier, all employers with 500 or fewer employees, and we're waiting for Department of Labor regulations regarding employers who have fewer than 50 employees, where it will be a hardship to enforce this law. It's available to any employee who's been employed for 30 days or more. And what the law provides is for the first 2 weeks of leave to be unpaid, and then the following 10 weeks of leave are paid at not less than 2/3 the regular rate based on the employee's normal hours, which I'll explain in just a moment. And that pay is capped at $200 per week, or $10,000 total per employee. So this law applies to full-time, part-time, and employees with irregular hours. The way that you would calculate the regular rate, of course, for full-time employees, it's the rate that they have actually been paid. For part-time employees and employees with irregular hours, the Department of Labor provides some alternatives. Typically, the regular rate of pay will be calculated based on an average of the employee's hours or earnings in a 2-week period, in a typical 2-week period. If that doesn't accurately reflect the pay for that particular employee, the employer can choose to use a 6-month period instead of a 2-week period to determine what the employee's normal rate is, or regular rate. If the employee hasn't been employed for 6 months, the Department of Labor indicates that the employer can use the average hours that were agreed at the time of hire, or if there's no such agreement, then the employer can use the average hours over the entire employment, even if the employment is shorter than 6 months. So that's how you would calculate the regular rate to be used for this pay. And please be aware that for non-exempt employees or hourly employees, the regular rate includes overtime hours. So if the employee typically works overtime hours, those hours must be included. This is not work from home. It doesn't apply if the employee is working or teleworking. Employees can elect to use available paid leave during the first 10 days, but the employer cannot require it. The employee is also entitled to 12 weeks of job protected leave, even if they reach the pay cap, and then some of the leave ends up not being paid under the law. So it's 12 weeks of leave, unpaid for the first 2 weeks, and then paid for 10 weeks if the pay cap allows full pay. The employee has to be reinstated at the end of the leave to the same job that they had before the leave began. However, if your organization has 25 or fewer employees, and if the position has been eliminated during that time period, you don't have to reinstate the employee, but you do have an obligation to make a reasonable attempt to reinstate that employee if it occurs, if you have a job within the next year. So you have a reinstatement obligation for a year if you're less than 25 employees and the job's been eliminated. One other thing that I want to mention regarding the family leave requirement is that employers of healthcare providers and emergency responders can exclude employees from these requirements. So you don't have to provide this leave if you are an employer of healthcare providers or emergency responders. So they're exempted from this law. Another important point is that the statute does not provide for a private cause of action for civil liability for employers with fewer than 50 employees. So employers with fewer than 50 employees, your employees cannot sue you to enforce their rights under this portion of the statute, under the family leave portion. And I think I saw a couple of questions go by related to whether this covers employees taking leave because they're caring for a child who is ill. And that is not the reason for leave. The only reason for family leave, and I'm not up to the sick leave provision yet, the only reason for family leave is leave to care for a child whose school or place of care or child care provider is unavailable. This family leave portion does not have to do with sickness. And the school, the place of care, or the child care provider have to be unavailable.
Lori, this is Sarisha. I have one more question.
So that's the leave requirement under the Families First Coronavirus Response Act. Next, I want to talk briefly about the paid sick leave requirement under this same law. So as you can see from this slide, paid sick leave of up to 80 hours, and I'll explain how those hours work for part-time and employees with irregular schedules. Employees are entitled to up to 80 hours of paid sick leave for any of the 6 reasons that are shown on your screen. So if the employee is subject to a quarantine or isolation order, if they've been advised by a healthcare provider to self-quarantine, if they're experiencing symptoms or seeking medical diagnosis, if they're caring for an individual subject to a quarantine or isolation, or advised by a healthcare provider to quarantine, if they're caring for a child, if the child's school or place of care is closed or the provider is not available, and I'll explain how that interacts in a minute, or if they're experiencing any substantially similar condition. For reasons 1 through 3, the employee is paid at the employee's regular rate, which is calculated the same way I described before, but capped at $511 per day up to $5,110 total per employee. That's a leave for their own illness or quarantine. For reasons 4 through 6, which relate to caring for someone else, those hours would be paid at the employee's regular rate based on the average hours in a 2-week period, capped at up to 200. Oh, I'm sorry. It's just the regular rate. It's not based on it. The average is one of the calculation methods. It's paid at the employee's regular rate up to $200 per day, up to $2,000 total. And that's to care for others or any other substantially similar condition. And again, employers of healthcare providers or emergency responders can be excluded from these requirements. With regard to the first 10 days of family leave, which are unpaid, the days that we talked about can be covered under this law. So you can use, an employee can choose to use the paid sick leave under this sick leave provision to cover the first 10 days after they take family leave. So hopefully that makes sense. The first 10 days of family leave can be paid. The employer cannot require them to do so, but they can, the employee can elect to take the first 10 days as sick leave instead of family leave.
I did. I'm relaying a question from one of the attendees, and they're wondering if the 2 weeks paid leave has to be taken consecutively. So please hold on. All right. Can you hear me, Lori? No worries. Do the 2 weeks of paid leave need to be taken consecutively, or can they be taken in batches, like 2 days 1 week, 3 days next week?
Well, that's a great question, and it's a little bit unclear. The employee is allowed to take up to 80 hours. So, you know, if they haven't taken the full 80 hours, they'll still, for a full-time employee. So if they haven't taken the full 80 hours, they would still have whatever's left of that available. And this only applies from, you know, April 1st through December 31st. So during that time period, it seems to me, although we haven't seen a complete answer to this in the regulations yet, that they would be able to take the time in installments if it was necessary. But remember that this is sick leave. So it may be that employees aren't really taking it that way. Okay. Let me mention a couple of other things about the Families First Coronavirus Response Act with regard to both sick and family leave. Under both of these requirements, the organization is going to be paid back by the government for allowing employees to take these leaves. So you'll need to track very carefully how much leave time is taken and how much you pay under this law in order to be able to obtain that sort of refundable tax credit that is coming to you. The way that it's going to work, and I will say before I share this information that I'm not a tax lawyer, so this is, you know, what I understand. And my understanding is that you'll be able to recover the amounts that you've paid through a refundable tax credit, which means that it will come from the employer portion of your Social Security taxes. You will keep the portion of Social Security taxes that you would normally pay, and if that's not enough to cover the wages that have been paid under the family leave and the sick leave provisions, then you'll apply to the government for reimbursement of any remaining amounts. Now, please be aware that the Department of Labor and the IRS have not yet issued regulations to outline the specific procedures in more detail, and will provide more information through a legal alert once we have more information from the government agencies about the logistics.
And Lori, we have a question going back to healthcare providers. You mentioned, does this apply to any employee of an organization that provides healthcare, or only to those specific employees who are providing those healthcare services?
It applies to healthcare providers and emergency responders under the statute. I'm not sure that it's defined any more thoroughly than that. So that's another question that we're going to have to get some more clarity about. Sure. Okay, moving on to other leave. Now, let me depart from the Families First Coronavirus Response Act and talk a little bit about organization policy and what your policy might provide with regard to leaves. So if you have provisions in your policies for leaves other than those provided under the Families First Coronavirus Response Act, your policies will govern whether paid or unpaid leaves are available. And for leaves other than those under the Families First Coronavirus Response Act, you can choose to require employees to use accrued paid leave time before they use available unpaid leave, as long as your policies allow you to do that. One thing you might want to keep in mind is if you're contemplating any changes to your policies because of what's going on in the world right now, please be sure that you follow the appropriate processes to change your policy, which might require a board vote. If you require employees to use available paid leave before they use unpaid leave under your own policies, be sure to administer those rules consistently. Don't treat similarly situated employees differently. And while I recognize that most of you probably don't have the budget to pay for items that aren't required, if you do want to provide paid leave or any kind of benefit that wasn't previously required, make sure that if you're deviating from your normal policies, that you're very clear about the fact that something is being put in on a temporary basis, and that when and if that policy is going to revert back to what your policy was before this crisis, make sure that's clear to your employees. Make sure it's clear that you're not promising them this benefit, whatever it is, for an indefinite period of time, that it's only going to last as long as the crisis lasts. One other thing I wanted to talk about is the application of absence or discipline policies during this crisis. Employers can legally apply their regular employee policies even during this crisis if those policies apply. So one thing I do want to caution you about is that if you're applying an absence policy or a discipline policy, please be sure you're not penalizing any employee for taking a protected leave. And that would include Families First Coronavirus Response Act, under the Family and Medical Leave Act, if that applies to your organization, or for any other protected reason like a leave protected by the Americans with Disabilities Act. But with that being said, I also want to make sure you're considering not only the legal implications, but also the practical implications of applying things like absence or discipline policies during this crisis. Please consider the impact of your policies on your workforce. You don't want to provide an incentive to an employee to come to work if you're still working in the office if they are sick. So please consider how you want to use your disciplinary policies or absence policies during this time period, and make sure you're not giving people an incentive to come to work if they're sick. The other thing I wanted to mention to you with regard to your policies is you need to be consistent in the way that you're treating employees, the way that you're treating everyone in your workforce. And when I say be consistent, that doesn't necessarily mean you have to treat everyone exactly the same. You need to be sure that if employees are treated differently, if something happens to employee A that's a little bit different than the experience that you're going to have with employee B, that you are that you have a legitimate business reason for why a rule applies to one employee in one way and to a different employee in a different way. So, for example, depending on their job duties, some employees may be able to work from home and other employees may not be able to work from home. So long as you have based the decision on the duties of the employee and the availability of work, that's fine. You can make different decisions related to different people because of the differences in their situation, their work duties, or the way that they are performing work. Just be careful that you're not treating similarly situated employees differently. I see there's a policy question. If an organization is already paying an employee their full salary under the organization's normal sick leave policy, does this apply once they take all that leave? I assume you're talking about the 80 hours of sick leave. This is above and beyond any paid sick leave that you already provide to employees. So they can take this leave in addition to any other leave that you offer to them. And you can't use it to replace your sick leave under your policies. So if you already provide sick leave, you'll have to provide an additional 80 hours to full-time employees, and prorated amount over 2 weeks to employees who work less than 80 hours. Okay, let's talk about your employees who might be working from home. If such work is possible, your employees may be working from home. If you don't have a policy that addresses how employees can work from home, you might want to consider adopting one. And in your policy, you should consider how employees are able to work from home, which employees are able to work from home, and address any rules related to teleworking or working from home. One thing that you want to be sure to communicate to your employees is that, sorry about that, let me move that. Apologize. We're all working from home, and I'm working from home too, so you're hearing my telephone ring at my house. I apologize for that. So in your policy addressing work from home, one thing to consider is to ensure your employees understand that any employee policies that apply to them when they were working in your workplace still apply to them when you're working from home. So things like your anti-harassment policy, your non-discrimination policy, those policies all still apply. Policies that relate to how they use organization equipment, timekeeping, and other issues related to how they complete their work still apply even if your employees are working from home. Another thing that's important for you to know and realize is that employers can still manage performance of employees even if they're working from home. You still have the right to conduct performance reviews, to issue warnings if performance isn't satisfactory, and to provide feedback to your employees. One other thing you should think about is how you're going to protect confidential information that employees have access to when they're working at home or online. Are they using your equipment or systems? If not, is there some way that you can protect confidential information to which they have access to ensure that it remains confidential? You need to be very careful about how sensitive information is communicated among your employees. One thing I did want to mention is if you're a healthcare provider and you're doing work over video platforms like Zoom or Skype or other video conferencing platforms, be aware that the Office of Civil Rights, which is the agency that oversees HIPAA compliance, and HIPAA is the Health Insurance Portability and Accountability Act that governs the confidentiality of medical information. That office issued a statement indicating that it wouldn't impose sanctions for the use of telehealth remote communications during this public health emergency. So you can breathe a sigh of relief if you are working over Zoom or Skype and you're sharing some medical information in that manner. Are your jobs changing in any way due to the crisis? If your employees are working, has anything about their job changed? Are they performing the same work duties? Are they working the same hours? Have you reduced salaries or pay? And if there are changes to employee duties, hours, or pay, have you thought about the legal implications that are caused by having those things happen? I'm going to talk a little bit in a moment about the Fair Labor Standards Act and changes to jobs could cause under that act, and also about unemployment. Before I talk about that, I want to mention the CARES Act, which was signed into law on Friday. I'm not going to be able to cover it in a huge amount of detail because I think that would take a whole webcast by itself, but I want you to be aware that this new law provides access to SBA loans for nonprofits for purposes such as payroll, benefits, mortgage or rent payments, utilities, and interest on other debt. And the amount of loan funds that are available is based on a formula that's related to your payroll. The law provides loan forgiveness for loans that are used for payroll, for interest on mortgages, rent, or utilities, and access to the loan forgiveness is reduced by any employee cuts or reductions in wages that you take during the covered period. The covered period for purposes of that law is February 15th, 2020 through June 30th, 2020. So if you have done any reductions in wages or cuts to employees or are contemplating doing that, please consider the implications with regard to the loans that are available under the CARES Act if you're interested in applying for those loans. We issued a legal alert on Friday afternoon, which you can find on our website, and there is a lot more information and detail in that legal alert about how to calculate the amount of loan for which you're eligible, and then the provisions that relate to this loan forgiveness. And please contact your pro bono partnership attorney if you have additional questions about those. Let me address the potential implications of job changes or pay changes with regard to these other laws. First, the Fair Labor Standards Act. The Fair Labor Standards Act is the law that distinguishes between exempt and non-exempt employees. It requires that employees who are non-exempt be paid at least minimum wage and overtime for hours over 40 in a work week. Exemption applies only if the position satisfies all of the pay and duties requirements of a particular exemption. So if you have an exempt employee whose pay or duties is being changed, please be aware that that change may change the status of that employee as exempt or non-exempt. With regard to duties, if the job doesn't fit all the criteria for the exemption anymore, then that employee will become non-exempt. With regard to pay, if pay is reduced below the salary threshold, which currently is $35,568 a year, or if you convert pay to hourly pay because you're changing people's hours, that employee may also no longer or will also no longer be exempt. Also, with regard to reducing employee pay, please be sure that pay reductions are prospective, that they apply only to future pay and not retroactive. It's a good idea to set changes in pay, particularly for exempt employees, at the beginning of a work week so that you don't have an issue of an employee who's both exempt and non-exempt in the same week. It's just going to get way too complicated for you to administer. Bear in mind that for exempt employees, if they work at all during a work week, then you have to pay them for the whole week. For non-exempt employees, that rule is different. For non-exempt employees, you only pay them for the hours that they actually work. And you can a little bit more easily reduce a non-exempt employee's pay without worrying at least about their status. Of course, it raises many other issues, but without worrying about their status. If the hours are reduced, let me mention this first. If for all non-exempt employees, including any employees who were exempt and their status has changed to non-exempt, please be sure that you're continuing to keep timesheets and track hours for folks who are still working for you. And those requirements don't go away even in this crisis. And of course, even if people are working from home, you still want to know how many hours they're working. So you may need to continue to track their hours if they're non-exempt employees, if they become non-exempt, or of course, if you have other reasons for tracking hours like compliance with your grant requirements. So just keep all of that in mind. One other thing to remember, if hours are reduced and your employees participate in group health care coverage or other benefit plans, please be sure to check with your benefit provider to determine if the eligibility of those employees for benefits has changed. It's possible that the reduction of hours can be an event that triggers COBRA coverage, and then the employee will have to pay for their own coverage rather than being included under the employee participation if they go below the number of hours that are required to be worked for your plan. So do keep that in mind. And other kinds of benefit plans may have hour requirements for participation as well, and you'll need to check if those need to be converted to personal plans rather than going through your group plans. So keep that in mind as you're considering reducing hours for employees or changing their jobs. Okay, one thing I want to mention before we dive into unemployment requirements is I wanted to talk a little bit about the interaction between the Families First Coronavirus Response Act, the family and sick leave requirements, and unemployment and how that works. First of all, and I'll explain this more in a minute, employees who are laid off or furloughed, which is really a temporary layoff, it's just a fancy word for a temporary layoff, cannot take leave under the sick leave or family leave provisions during their layoff, but they are eligible for unemployment. In addition, if you have an employee whose hours have been reduced, they can take family leave or sick leave with regard to the hours that they're still working, but they would also be eligible for unemployment for the hours that they're not working due to the hour reduction. Hope that makes sense. If you reduce an employee's hours, they may be entitled to two kinds of benefits. First, when you reduce their hours for lack of work, the hours that have been taken away will be eligible for unemployment payments. For the hours that they're still actually working, say I was an employee and I worked for you 40 hours a week and you've now reduced my hours to 20 hours a week. For the 20 hours that I'm no longer working, I can collect unemployment, but work is available to me for 20 hours a week. However, if my child's school is closed and I have to take care of my child, I can take leave during those 20 hours that work is available to take care of my child, and I can receive benefits under the Families First Coronavirus Response Act just for those hours that I was supposed to be working. And as an employer, you can be reimbursed for those hours, but employees cannot overlap leave and unemployment. Now, let me talk a little bit about unemployment and what's available through unemployment. There are two types of unemployment claims that are now available in Georgia: partial claims and what I'll call regular claims. Let me talk about partial claims first. Partial claims for unemployment are claims that are available if an employee has had their hours reduced or if they have been furloughed or temporarily laid off. This is a layoff or furlough where the expectation is that the employee will be called back at the end of the crisis and be able to engage in their work again. In a situation where one of those things has happened, the employer, not the employee, must file the partial claim. And if you go onto the Department of Labor's website, you will see a banner at the top of the page that tells you where to click to get information about filing partial claims. Please be aware that if the employer fails to file a partial claim that is paid, then the Department of Labor will charge that claim back to your organization. If you do file partial claims correctly, the benefits are being funded by the government. So you will not have to pay those claims or have them deducted from your account. For regular unemployment claims, which are claims that are filed by an employee if that employee is permanently out of work, those claims are proceeding as normal. So the employee would go and file the claim. When you terminate the employee, whether for lack of work or any other reason, with no expectation that that employee will be called back to work, then you should issue a Georgia separation notice, and the employee takes that separation notice and files a claim. So those are the two different types of unemployment claims that could be filed. please remember that the employer must file the partial claims. Now, a few more things about unemployment. Last week, the Department of Labor issued an emergency order that changes the way unemployment is being calculated. You may know that the maximum benefit for unemployment, at least prior to Friday, was $330 per week. And there was a formula that the Department of Labor used to calculate benefits. What they have said now is that they're going to calculate benefits based on that $330 maximum benefit, reduced by any amount over $300 that the employee has earned. So that's how they're calculating benefits now. The emergency order also extended the eligibility for benefits from 20 weeks to a maximum of 26 weeks. Now let me talk for a minute about how that interacts with the CARES Act, which was passed on Friday. Under the CARES Act, there's going to be an increase in the weekly amount of unemployment benefits for which employees are eligible. The federal government is adding $600 per week to the benefits for employees who are eligible for unemployment payments. In addition, the CARES Act provides expanded unemployment insurance eligibility for individuals who weren't traditionally covered by unemployment, including self-employed individuals and independent contractors. And these benefit expansions under the CARES Act apply for the period from January 27th, 2020. So it's retroactive to January 27th, 2020 through December 31st, 2020. Now, how do we take advantage of these benefits? First, I want to let you know that the Georgia Department of Labor has posted a notice indicating that they're going to provide additional instructions about the expanded benefits and benefits for independent contractors once they receive information about accessing the federal funds. I think that notice went up this morning, so we don't know exactly when they're going to start applying these. So that will be information that is forthcoming. I see there's a question, what if we're not covered by state unemployment? Even if you're not covered by state unemployment, you should still file partial claims. And in addition, if you are permanently terminating employees, give them a separation notice and have them file for unemployment, because the government benefits are applicable. And so even if you're not covered by, even if you don't contribute to unemployment, you will, your employees will be able to collect unemployment under the government benefits. One other thing I wanted to mention is that on Thursday at 3 o'clock, we are partnering with the Georgia Center for Nonprofits to put on a webcast that solely addresses unemployment issues and questions. And I suspect that by Wednesday, hopefully, we'll have some more information from the Department of Labor, from the Georgia Department of Labor, about how they're going to administer the claims that relate to the federal funding. So please tune into that webcast on Thursday, and hopefully we'll have some more information then than we have now about how that $600 benefit is going to work and how traditionally folks who traditionally have not been covered will be covered. I hope that that information has been helpful. I'm happy to take questions, and I'm going to ask Sarisha to help me with managing the questions that have come in while I was talking. And I see there's one on the board right now. We're a healthcare provider and employ less than 50. Sounds like an exemption. If I nevertheless, I think you may be right. If I nevertheless elect to pay the staff any of the benefit, do I forfeit the exemption? I don't think so. It allows healthcare providers to make an assessment about who is and is not eligible for the benefit. So you should be able to provide it to employees who are not, crucial workers, and not to those who are healthcare providers or emergency responders. If someone is making $80,000 as furloughed, would they get, if someone making $80,000 is furloughed, would they get 330 under Georgia Department of Labor and 600 from the Fed? I believe that is correct. Those are the 330 is the maximum benefit amount under Georgia law, and then they would also get the federal amount. More regulations hopefully are coming to clarify how that's going to work. But it's, you know, it's not tied to how much the employee is making. Their salary is not relevant to how much their benefits are going to be unless they're still getting paid. Someone who's still getting paid cannot recover unemployment. And if they're getting paid partially, then the Georgia DOL will look at how much they're getting paid in determining the benefits. The question is, what if an employee's hours were reduced before COVID from 35 to 25 hours based on the employee's requests? If they were reduced before COVID, not because of COVID, then these benefits would not apply. Sarisha, do we have other questions?
Lori, if you can repeat this after I say it, because I believe some people are having problems hearing me. Most of the other questions have to relate to the SBA loans and the CARES Act. So we'll do a webcast on that later this week.
Okay. Oh, okay. I'm being informed that a lot of the questions that are left relate to the loan forgiveness and the SBA loans. Please be aware that we're going to do another webcast on that subject, I believe later this week. So the announcement for that webcast will come out shortly. I think it's going to be in our Thursday webcast. So we'll provide more information about that. Please be aware that this session was recorded. So if you missed anything that was covered during the session, you can go back and look at the recording. It's going to be posted later today. Question, do we have to file partial unemployment for an employee who worked only a few hours a week and is not interested in recouping that money? For any employee whose hours were reduced due to the public health crisis, I would suggest filing the partial unemployment. Is February 15th the date to use for the start of COVID-19? I can't answer that question. These laws are tied to specific dates. So the dates that I gave you are the dates on which the laws become effective. But I'm not sure I can answer that question about when the pandemic started. Do these unemployment benefits apply to contract 1099 administrative workers? Yes. The unemployment benefits that have just been passed in the CARES Act also apply to contract or 1099 workers. What is unclear at this point is whether those contractors, will have to file for the unemployment themselves or whether they would be included in the partial claims. And I am hoping and expecting that the Georgia Department of Labor will put some guidance out about how they're going to administer that and where those claims need to be filed. Next question, what proof would we need to produce if this claim was initiated by an employee, even though, I'm sorry, I don't understand the question. What proof would we need to produce if a claim was initiated by an employee, even though they requested a reduction of hours to initiate on March 16th? If an employee requested a reduction of hours and it wasn't caused by COVID, then it's not part of the claims you can make. And I don't know if I'm misunderstanding that question, but please contact your pro bono partnership attorney if you have specific questions related to your workplace that I haven't been able to answer today. I'm going to take one more question. We are an essential service provider. Do the laws affect us? If you're a healthcare provider or emergency responder, then you don't have to comply with the leave laws. As far as the CARES Act, I don't know the answer to that question. And, you know, I'm sorry, it's just kind of an ambiguous question, and I don't know the answer. It really depends on, if you're talking about the leave laws, it depends on whether you're providing the services that are excluded from it, or whether you're 50 or below and it's a hardship to your business to comply with it. I hope that this presentation was helpful to you. Please, as I mentioned, feel free to watch the recording, and please contact your pro bono partnership attorney if you have additional questions that we weren't able to address. Thank you for your time today and for everything that you're doing.